Today on Let's Talk Crimes, Frank is going to talk to us about search and seizures. So Frank, tell us about search and seizures.
Good evening, viewers at Let's Talk Crime with Frank. Good evening, Mr. Narrator. Search and seizures, that is one big topic. Let me tell you where it starts, where it all begins. It's actually a constitutional, United States Constitution, Fourth Amendment. The Fourth Amendment, folks, is part of the Bill of Rights. And I'm going to read it because this is really one of these subjects that we can sit here for days, but we're going to touch bases on it. I think you need to read where it begins. The Fourth Amendment of the Constitution states the following: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause. What does all that mean? Everybody has a reasonable expectation of privacy in their houses, their effects, and their persons. That right, according to the Constitution, cannot be violated by government unless there is a warrant. And no warrant could be issued unless there's probable cause. That's why Fourth Amendment is something that is always argued in criminal cases, because many criminal cases begin when an officer searches an individual and finds evidence that later he uses to arrest him.
So what are some examples where it may come up that you've seen where an officer searches without a warrant, or that kind of situation happens?
Absolutely. Let me give you the traditional stops that end up with this question. One very typical one is a traffic stop. Officer stops somebody for a traffic violation. While he does that, if he does an illegal search, for whatever reason, he tells the driver to get out of the car and decides to search the car.
Right.
That's an unreasonable search because he stopped that individual for a traffic stop. Person has a reasonable expectation of privacy in his car. Now, what are the exceptions? There are many exceptions to the rule. One way that an officer could do a search and seizure without getting a warrant is with consent. It could be as easy as saying, "Sir, can I search your car?" He may have no real reason to search it, but he can ask you and you can say yes. And this is where it gets tricky. If you saw my program on Miranda warnings, right? This is a little different. With search and seizure, you don't have to be admonished by the officer that you can refuse.
All right. So they can trick you. They can
Correct.
Trick you.
With Miranda rights, the officer is going to question you about a crime, and he has to read you the Miranda rights. He has to tell you that you have the right to remain silent. With the Fourth Amendment search and seizure, he doesn't. He can say, "Sir, can I search your car?" Doesn't have to tell you that you can refuse. And most people sometimes are nervous. They say, "Sure, go ahead and search the car." Out of fear. Yeah. And now what began as a traffic ticket for blowing a stop sign ends up with a possession of cocaine, possession of firearm by a convicted felon, and who knows what else.
All right. And what happens when they illegally search your car or maybe your house or whatever? What happens to the officer? What happens in court?
That's a good question because you just wonder, okay, so now they broke the law, okay? And according to the Fourth Amendment, they searched me unreasonably. They discovered something, and that ended up being the evidence for my arrest. So how do I fix the problem? Right. There's something called the exclusionary rule. What the exclusionary rule says is that if the government unreasonably searches and seizes something from your person or your property, and it's proven that it's done unreasonably and unlawfully, the exclusionary rule prevents the state or the officer to use that against you. That's sort of the sanctions against the government. Where you got it illegally, well, buddy, now you don't get to use it against them. And many times that item, for example, on an armed robbery, If they searched you illegally and they found a gun, the gun may be the difference between you going to jail or being acquitted.
Yeah. And does it ever matter, like, the severity of what they found? Like, let's say they illegally searched your car and they found 5 pounds of cocaine.
It shouldn't matter. An unlawful search and seizure is an unlawful search and seizure no matter what you find. Then there's reality. And let's talk crimes. We like to talk law, and then we like to talk reality. Would the gravity or the importance of the evidence found unlawfully make a difference in a court of law in ruling whether it was unlawful or not? The truth is, or this is my opinion,
right.
The truth is that if you have a homicide case where somebody's deceased and a judge is presented with a motion, that's the mechanism you will use, a motion to suppress evidence because it was seized unlawful. In a very serious offense like homicide, I would probably fair to say the judges are more conservative and they probably think harder about granting a motion like that where it could land the person out of custody, and they would probably allow that to go to the jury instead. That probably shouldn't be the case, because if the motion has a legal basis, it should be the same regardless of the charges. But I fair to say that the severity of the charges will influence the court's decision.
And I know it's kind of a weird question, but do the cops ever get in trouble for illegally searching a car?
I personally have, unless they really commit a crime in the process of it. Sometimes it's really what the departments and the officers will always argue is that they believe that they have probable cause to either use one of the exceptions to the search and seizure warrant, or they just made a bad call. So the answer to that, the short answer is no. I'm sure that there are some exceptions and sometimes officers have gotten in trouble, but the real sanction is that the evidence will not be used against the defendant.
All right. Well, I think that's the end of my questions.
And it goes on and on and on. But just to give you an example how everything could be argued. For example, there's an automobile exception. That's one of the exceptions to searching an automobile without a warrant. Remember, under the Fourth Amendment, you need a warrant, a probable cause. So there are exceptions. The automobile exception, it says that if an automobile, because it's a movable, an automobile could be moved, then the officer should be able to search it if he feels that there's evidence of a crime there that he could lose if he lets the automobile. So this is an example, and this is one of the cases out there. I'm not sure if it made it to the Supreme Court. But officer finds an abandoned car. Abandoned car has all 4 flat tires, is in an abandoned area. Car is reported stolen. He decides to pry the trunk open of the abandoned car.
Right.
Pry it open. It doesn't open easily. He has to pry it open. He finds 10 kilos of cocaine. Then the investigation leads to a culprit, and the culprit is charged. Well, question to you, is that a legal search or an illegal search?
It sounds illegal.
It sounds illegal. The officer may argue that he thought he was under the automobile exception. The truth is, the car is abandoned, it doesn't look functional, and all 4 tires are flat. Right. So the car was not movable, which is the purpose of the exception. So in that case, the court would probably say, no, it doesn't fall under the exception. You need to go to a judge or magistrate, and you need to get a warrant. So that's how it goes back and forth.
And can they get a warrant after the fact? So let's say with the abandoned car, he found the kilos inside, and they say, you can't use this evidence because you searched it illegally. Now, can he go back and be like, can I get a warrant for?
No, what he can do is if he spots the car and it's something, if he has reasons to believe that there may be cocaine in there, right, then what he does, he secures the car, meaning that they'll post an officer or 2 on the car so that the car won't be moved, and then they'll go get a warrant. That happens all the time. Okay. In homes, they'll secure a crime scene, a murder scene. Yeah. Nobody can come in and out of the property while the person gets. And just quickly before I finish the episode, there's just so many scenarios. But a common one is officer knocks on your door. He has reasons to believe somebody told him, or for whatever reason they feel you have narcotics inside the house. So he just tries you, knocks on the door. Sir, how are you? This is Officer so-and-so. May I have consent to search your home? For whatever reason, a lot of people get nervous and they say yes. Remember, he doesn't have to tell you that you have the right to refuse. And once he goes in there, whatever he finds, he can use against you because you gave him consent. And that's just an example. It's a very, very large area. It's a heavily litigated amendment. In criminal practice, you're going to see Fourth Amendment motions all the time. Just think when you're being stopped by an officer, if he's asking you for consent, don't just answer. Think about what he wants consent for. And remember, it's okay to say no. I hope you enjoyed it. This is really a topic that probably merits more episodes. And have a good evening.
What you gonna do when they come